Good afternoon, everyone. I hope I'm audible. Welcome to
Yes,
our,
sir.
yeah, thank you, ma'am. So, welcome to our session on navigating labor law obligations under the IBC, balancing employee interests and successful resolution. In fact, on a previous occasion, I had the opportunity to cover a similar topic. But of course, now this has to be linked with the successful resolution in terms of resolution of the corporate data. So my earlier session, I was focusing more on how labor law and IBC go hand in hand. That was the time where my co-host was or the co-speaker was discussing on the Companies Act vis-a-vis the IBC, while I was discussing on how the labor law works alongside IBC. But now today's session will be more on how we navigate these obligations under the code as RPs, and of course at the same time by balancing the employee interests and ensuring the successful resolution of the corporate data. So that would remain the theme of this session. So though some of the slides are kind of replicated from my previous session, but the point of discussion would vary, and the way we direct this session would also definitely be different from how we have taken up in the previous session. So first and foremost, I divide this our session into two segments. Sorry, into two segments. One, the legal framework, how the law and the labor law and the IBC, how do they provide in terms of what has to be done, and second, the practice in terms of how we need to run the process and see, how what kind of measures we need to keep in place to ensure that there is no non-compliance or there is no illegality in terms of how the resolution has been taken up, right? So this is how we are going to divide our session into. So setting the context first, like labor law per se, though might be like in majority of insolvency matters which we handle, at least I mean where I was the RP initially, I never had the opportunity to work as RP of a company which was having operations, but it was gradually gradually once the code got like once the banks got acquainted with the code, then RPs got acquainted with the procedures and all, even companies undergoing operations have started coming up and into IBC, and we as RPs got opportunities to function as RPs of ongoing concerns, right? The going concerns. No, in fact, one of the examples of a going concern under CARP, as everybody or every one of us knew, was of SR Steel, which was actually clocking more profits even during the insolvency process. But similarly, we have examples of Uttam Group companies and many companies which were under CIRP. Even I was fortunate to work as an RP of one company which had operations and where we were actively dealing with employees on a day-to-day basis of more than 100 to 200 employees, and I was assisting RP in some cases where we had employees more than 200, 400, and all in different processes. So now during my during that particular opportunity of mine where I was working under the under the direct directly reporting to the RP, or where I was the RP where the company had operations, one thing which I understood was that the very core idea of IBC was to make sure that the company functions as a going concern, right? So the IBC, the initiation or the commencement should not stop anything which the company was doing prior to that in terms of business, right? So the code was never meant to stop all the operations, sell everything and dispose of it. That's not what was the idea, right? Unlike earlier where one of the grounds of inability to make the payment was winding up, right? So I mean, like, inability to make the payments was one of the grounds for winding up, whereas now the inability to make the payment, which is a default, is one of the grounds to initiate a process to resolve your position, resolve your defaults, to resolve the company, right? So the law strongly believes that probably there is some core defect in this company which can be resolved, right? Which can be resolved by way of some process through which this company can be put in a safe hands who can run this company forward. But during the process, like before, like that the moment it gets into CIRP, the moment we until the moment we hand it over to another safe hands, there comes the responsibility of an RP to ensure that the interests of all these workers and employees are being taken care of. Because earlier, that is prior to the commencement, all the workers and the labor, the employees, they have their hopes from the top management, the directors, the MD, the founders, right? So they always root to them for any of their problems, for any of their concerns, right? So even including increments, bonuses, everything would have been decided by the top management. But then the moment this NCLT order comes, from day zero, the RP will come, the IRP or the RP will then be it will be stepping into the shoes. And you know, in fact, the existing management will be handicapped even if they want to take any decision, because ultimately, even though the inception of the decision making comes from them in a going concern matters, because we will 100% have to rely on the existing management's expertise, their employees, the team, and everything. But ultimate decision making again will be in the hands of the RP, right? So, like, given this context, I'd like to give you an example in one of my matters how what happened, right? So, it was a case where we had, as I said, there were more than 100 employees, and there was one sorry workman, and we had a sorry. Yeah. So there were more than 100 workmen, and I was uh, handling, you know, um, the negotiation with the workmen union, because since the company was under stress for past almost 2 3 years, they never had increments. So they were all put together, all of them through some political influence have started talks, to pressurize us to give increments during the process. Now, of course, it was a tough decision to make, because the company itself is under CIRP. Now, where come the question of increments to workmen or the employees? But at the same time, it is not possible for us. Um, at the same time, it is not possible for us to not uh, take up this not take up the request from the management, from the employees, for the same reason that if they stop coming to the factory, if they stop doing what they're supposed to do, then again that would be a huge problem for us, right? So with all that in mind, we have taken the COC into confidence. We have informed the COC that there is a huge possibility that these workmen and the labor may stop coming to the factory if we don't consider their request. At least let us propose something on table, as minimum as 8% or 10%, something let us put on table to them, so that there is some level of confidence. So there were two demands coming from them. One was they wanted their assurance for next 5 years, and for each year they wanted us to agree on what percentage of increment we want to give. Second was, what is the percentage of increment? Now, this agreement for 5 years is a tricky thing, because if we do an agreement with the labor union, then as per the Trade Unions Act, and also, of course, now under the four labor law, the Code of Labor, it would have been impossible for us to, you know, do it, because ultimately I have to hand over the entire control to that of a new management. Now, if I'm handing over control to a new management, they would 100% not expect such kind of additional responsibilities, during the process, and that increment may or may not be in line with the understanding, or in line with the policy of the new management, right? So that was one tricky decision. So what we did was, we had to get the successful RA on board, we had to get the COC on board, and ultimately we had negotiated with the labor union and agreed on their increments. Of course, after a lot of negotiations, we have come to a consensus, and on a midway we have both have agreed and ultimately locked that as the increased price. Now, why I wanted to quote this example was that Technically, nothing of this sort, or nothing close to this would be there in any of our IBC or the regulations in terms of talking or negotiating with the labor and all that. Obviously, the law doesn't want to stipulate everything what you need to do. Ultimately, when I get the powers, when the powers of the board is vested with me, I act as the board. Now, what all the board of directors have to do, I also have to essentially do the same. So that's the whole reason why in a company which is having a going concern, the labor law sits at the heart of the insolvency. It would guide us in terms of ensuring that the company does not fail, because if this fails, then the value of the company will 100% deteriorate, and the realization to the creditors and the stakeholders will also deteriorate, right? So hence that's, I mean, this is the context in which I would like to take this session forward. So workforce, like the kind of employees we have is that decides whether the company is a going concern or not, right? So without retaining the workforce, it is impossible for us to claim the status of a going concern. So we need to ensure that the workforce is there, right? Yeah. And second, in terms of the legislation, now as you all are aware, IBC is not a kind of a welfare legislation, because like all the labor laws per se are beneficial legislations, they're social legislations, right? In any country, they are meant to protect the rights of certain group of people, protect the interests of certain group of people, their health, their working conditions, all of it are stipulated so that industries or private organizations do not exploit the people's need of money, right? At the same time, or parallelly, if you see the IBC, no, IBC is a creator and control model, right? Now, in this, there is a strict commercial mechanism provided in terms of decision making, in terms of distribution, in terms of compliances. It's a pure economic legislation, while labor law is a beneficiary driven legislation or a beneficial legislation, right? Now this distinction is also important for us to understand while we are dealing with labor law compliances and during CIRP, right? Next, in terms of carve outs, like one may argue that notwithstanding anything contained in any other law, if there is any inconsistency between IBC and the other law, the IBC shall prevail. So certainly one can argue that IBC being a law, that should ideally prevail, But having said that, before we rely on 238, we should establish that there is an inconsistency, correct? But various precedents, that, like that of the Jet Airways or other rulings, have clarified that PF PF ESIC gratuity, they stand beyond the estate of the liquidation, estate of the beyond the liquidation estate, and they get that priority. That money cannot be used for distribution to any other creditors, right? So there is some level of protection of workmen even when the company is under CIRP. So we cannot override or use 238 to say that the labor laws are inconsistent, right? Because the IBC itself is giving certain labor protective carve outs to ensure the protection of the workmen. In fact, even section 53, right, what does it say? It says that wherever there is a workman due for past 24 months, the same shall have a same footing. They shall be on the same footing as that of any secured financial creditors. Similarly, employee dues for past 12 months, immediately next level, next immediately after secured creditors, it will be the employee dues for the past 12 months which will have the superiority in terms of distribution. So even the IBC recognizes certain rights of labor. It recognizes the need to benefit this workman. And yeah, so you know, in terms of the statutory provisions, as we see, the workman dues, right? So typically, in any matter where we might interact with workmen or employees is at the time of submission of claims. Now, just imagine, let's say there are certain workmen who did not receive their wages. Now, you can't expect all the workmen to understand the law, right? Because of course ignorance of law is no excuse, but at the same time we can't expect that all the workmen or the labor know the law or understand English. They may not be like even your email might mean nothing to them, right? So that is where we need to do an extra effort to engage with the HR, right, to get an authorization in favor of the HR to submit the claims on behalf of all the workmen, right, and furnish it before the RP. So that is a very important step we need to do, where we need to facilitate such claim submission by all the workmen and the labor. Right. And in terms of the definition, what are workmen dues? So, Section 326 of the Companies Act 2013 is a mirror section for Section 53, right? So, Section 53 provides for order of priority in terms of distribution under IBC, whereas when you are doing a winding up under the Companies Act, the order of priority is provided under Section 326 of the Companies Act. So, Section 326 of the Companies Act defines what are workmen dues, where it says it includes wages, accrued holiday remuneration, workmen's compensation, PF, pension, gratuity fund, sums, etc. All of would be coming under the definition of workmen dues. Now, let's pause here on workmen dues because there's an interesting issue we might face in a going concern matter. In fact, for that fact, any matter where employee dues are pending. Now, see, whenever the employer fails to deposit the PF contribution, both the employee's contribution as well as the employer's contribution. Similarly, whenever the company fails to deposit ESIC contribution, you know, both the employee as well as employer's contribution with respect to authorities, it becomes the responsibility of the respective authorities also to file a claim with the particular RP or the IRP, you know, by submitting their claim in terms of such pending deposits of PF by the company. Parallelly, even the employees they file their claims along with the PF dues. Now, if we are admitting the claims of both the workmen as well as the PF authorities, then it means I am typically admitting the same claim filed by two different parties. The claim is the same, right? Let's say there is an employee, Mr. A, and A has a PF payable of, let's say, 45,000. Now, A files a claim claiming for his salary of, let's say, 2 lakhs and the PF of 45,000. At the same time, the PF authority had also filed a claim only for the PF for all the employees, right? Or obviously, they file it on behalf of all the employees as regards the PF is concerned. Now, that also includes the 45,000 rupees of PF payable to Mr. A. Now, if I admit both these claims, then it amounts to the fact that I've admitted a total of 90,000 rupees of PF while the payable was only 45,000. Now, how far will that be a valid compliance is something which we need to figure out. So that's why in such cases, in my opinion, what the IRP has to do is to distinguish these claims and to only admit one claim, right, which would be of the PF authority, right? Because now we know, as per the law and recent Supreme Court ruling also, wherein it very clearly says PF dues, not the interest, not the damage, but the PF due will alone have the super priority. So, since the PF due alone has the super priority, to the extent of that PF dues, the PF authority should be admitted as a statutory authority or operation creditor claim. And to the extent of the employee who is claiming the PF due alone should not be admitted because that has already been claimed by the PF authority. right? So that explanation, we need to solidly explain it to all the employees, saying that, boss, okay, even though I am rejecting your claim, or even though I am not admitting your claim with respect to PF dues, the same is already part of the dues as part of the claim filed by the PF authority, right? So this distinction is absolutely necessary, otherwise our claim size would be a wrong indication of the total admitted claims. As we move forward, all the dues in terms of workmen or employee dues are treated as operational debt, and employees or workmen are considered as operational creditors. So even workmen or employees will have a right of initiating CIRP against the company. Of course, the only problem is they can't do a collective initiation, thereby they cannot prove a debt more than 1 crore. It's very rare cases where employees might do it, but workmen, it is impossible for a single workman to have more than 1 crore rupees of pending payable from the company. So though it is unlikely, but yes, as a matter of right, they do have it. And they, of course, they will have to submit their claims as operational creditors, as we discussed before. Next, in terms of Section 5, subsection 13, which defines corporate insolvency resolution process costs, it says that the cost of running the CD as a going concern are by default considered as CIRP costs, right? So the section clarifies that what all you incur for running the company as a going concern, the same shall be considered as a CIRP cost. So therefore, all your salaries, wages, and any other benefits which you are passing on to the employees or the workmen during the CIRP are by default considered as CIRP cost. And if at all there is any delay in making such payment, the employees or the workmen should be rest assured that at the time of making the payment under the resolution plan, their monies have got the ultimate super priority. Now, why this point is important is because, see, when we do, like, I'm also talking from my experience working in one such company assisting the IRP. See, the complication is when you have a company with its operations, but the company is under insolvency, one major hiccup any such company faces, unless the company has got good liquidity, is that of working capital crunch, right? Because the moment you enter into this process, all the suppliers will get, I mean, it's just an emotional reason, like how one bad news of a company's operations will hit on the stock market prices. It's purely the sentiment, right? Similarly, the all the suppliers, their sentiments in terms of their assurance to get the repayment from the company get saturated. So the moment they know the company is in insolvency, they'll start saying that no matter, boss, you just have to make us the payment in advance, only then we will supply you the material. Now, even if you explain them the code and tell them that, boss, earlier you would have just given a credit of 60 days, 90 days, and then maybe if it is not received, you may have to file a civil suit or a check bounce if the posted check is dishonored or whatever. But under IBC, you need not go anywhere. The money will come looking for you, because it is all a CARP cost, right? The RP or the IRP has to ensure that the CARP cost is paid up in full. Now, if that is not ensured, then there would be a problem, because it is a clear cut non violation, sorry, it's a clear cut violation of section 30 subsection 2, also the section 53 if it is liquidation, right? So if the CARP cost is not paid in priority, the plan itself will fail. Now this understanding, how many suppliers will have, right? So it's very difficult, because when I say supplier, we will not deal with the legal teams, right? And not every supplier might have a legal team, and we are only dealing with the business guys who have absolutely no clue how this IBC functions. And even if we are dealing with the legal teams, those legal teams may not be acquainted with how this IBC functions, right? So with all this in mind, the biggest challenge a company faces during CARP is a working capital
disruption, whereby you start making payments of advance for receiving your material, while your customer might extend the customer will not pay anything in advance to you, because the customer, you need to retain the customer. See, on one hand you need the suppliers to make the supply so that you can do the production, so you have no other option but to make them the advance payments. On the other hand, you have got the uh, your buyer, that is the customer, whom you can't leave. You have to retain that customer because they are the ones who are going to give you the business. Now, if this customer is, if I need to hold this customer, then I will have to listen to his terms also. So the customer may come back saying, "Chalo, I need more period for me to make the payment." Anything might happen. So typically, the entire working capital may get disrupted. So thereby, I am making the payments, but my receipts get delayed longer and longer. So therefore, there would be a liquidity crunch, during which time I naturally end up delaying in making the payment of salaries and wages, right? So it's natural that I will end up making delays in payments of salaries and wages. The moment I start making delay in payment of salaries and wages, that would that would directly, that would directly impact uh, uh, the morale of all the workmen and the labor, right? So that is the reason why, as and when possible, we need to explain all the labor representatives or the union leaders or the employee representatives. You should time and again explain them that, okay, there might be a delay during this month. We understand it is difficult for all of us to live without a monthly pay, right? A delay in it, right? At the same time, the company is in tough times. This is going to be resolved because it's a company which is a going concern, so some new entity will 100% come. But this temporary phase where there is a delay, you need not worry that this money won't come back to you. It is statutorily protected, or entire this money, whatever is payable, will definitely get back to you, right? So such kind of assurance we should be in a position to give to the employees and workmen. Of course, I'm not saying just because we say that they may start being supportive, they may still, of course, because see, it's ultimately at the end of the day, an employee works only for the, only in the sense of employee generally prefers that comfort of receiving the monthly salary on time. That was the whole reason why they they do their employment. Now if we uh, delay that, that will directly impact their performance. We can't demand them to start working on things. There will be a lot of hiccups in terms of having control over how much we can get the work done from an employee, as long as we are making delays in making their payments, right? So that difficulty is 100% there. But at least for those employees who are not looking for alternative jobs, this will give them a relief that, okay, so long as I'm with the company, my salary is protected. There is nothing for me to worry about because it is statutorily protected as a CARP cost. So that comfort we need to provide. Moving forward, yes, if there are any labor court disputes or industrial tribunal proceedings, the same shall also be under moratorium. So moratorium will be one good protection for you to ensure that all these labor issues are resolved directly and without any much of litigation in other forums. But of course, only one thing we may have to do is to intimate the respective forums about the pendency of the insolvency proceedings. As we move forward, section 20 and section 25 together provide for a responsibility on the IRP or the RP, as the case may be, to preserve the value of the assets, maximize the value of the assets, manage the company as a going concern, while at the same time conducting the CIRP process, right? So what all we do, what all decisions we take in terms of either retaining an employee or at times we may relieve employees, we terminate the services of employees during the process. Maybe there is one plant which is not operational, which is just under maintenance, right? And all the employees come, they are drawing salary, but there are no operations. So your fixed cost is increasing, or rather on a higher side, while you are not able to make any use of that particular factory. So at that time, probably the RP may take a tough call to terminate or lay off all those employees or retrench all those employees, which is very much possible under the law. right? So of course we will have to do it in accordance with the law, but at the same time, such decisions of the IRP or RP have a direct impact on managing the company as a going concern, right? So even that comes within the responsibility of the RP. Yeah. Oh, 1 second. Yeah. As we move forward, I think section 36(4), we already discussed that whatever funds are lying in the PF fund, pension fund, or the gratuity fund will not be part of the liquidation estate. Then subsequently, the workman's dues. Okay. This also we have discussed under section 53. Past 24 months workman dues will be ranking pari passu with the secured creditors, while the 12 months employee wages will rank immediately next to this particular priority. And as per section 21, the only thing is the employees representatives do not get any voting right or uh, participation right in the COC meetings. However, where there are no financial creditors, then yes, they have one representation in the COC, because it will be only of operational creditors. Moving forward in terms of compliances, see, the RP has to ensure that the labor laws are being met. Of course, the laws you see on screen, that is the Industrial Disputes Act, or the Employee Provident Fund and Miscellaneous Provisions Act, or Payment of Gratuity Act, Employee State Insurance Act, Payment of Wages Act, the Bonus Act, etc. These all are now combined into the four labor codes, right? So currently, what is relevant is only the labor codes, because all the labor codes have been notified. So the four labor codes we have are Code on Wages, Industrial Relations Code, Social Security Code, and Occupational Safety, Health and Working Conditions Code. So typically, what all you would have seen under the Factories Act would come under the Occupational Safety, Health and Working Conditions Code. In terms of Industrial Disputes Act, that is majorly covered under the Industrial Relations Code, Industrial Relations Code, right? And in terms of gratuity, ESIC, PF, etc., they are also covered under the other codes. And typically, the code on wages is what is taking care of the payment of wages and other laws. Um, yeah. So as we move forward in terms of the distinction, right? This is again just an additional side I thought we can consider. But yeah, before I go to the distinction, just a quick recap on this four labor codes. Firstly, on the code on wages, right? So the code on wages is replacing or has replaced the Payment of Wages Act, Minimum Wages Act, Payment of Bonus Act, and the Equal Remuneration Act, while the Industrial Relations Code, the IR Code of 2020 replaces the Trade Unions Act, Industrial Disputes Act, and the Industrial Employment Standing Orders Act, again an important legislation. Then the Code on Social Security, the main one, it has multiple acts being covered. So Social Security, as you understand, it's like your PF is one of a Social Security to protect you in terms of your savings. Similarly, your ESIC, right? So therefore, these legislations like EPF, EPF and Miscellaneous Provisions Act, or Employee State Insurance Act, Workmen's Compensation, Maternity Benefit, Payment of Gratuity, Employees Exchange, Act, or Cine Workers Welfare Fund Act, Building and Other Construction Workers Welfare Cess Act, and the Unorganized Workers Social Security Act. All these come under the code on social security. Then, as we move forward, the Occupational Safety, Health and Working Conditions Code, as I was telling you, majorly the Factories Act is what is covered under this particular legislation. And along with that, we also have the Mines Act, Plantations Labor Act, Working Journalists and Other Newspaper Employees Conditions of Service and Miscellaneous Provisions Act, Working Journalists Fixation of Rates of Wages Act, Motor Transport Workers Act, BD and Cigar Workers Act, Contract Labor Act, Sales Promotion Employment Act, the Interstate Migrant Workmen Act, the Cine Workers and Cinema Theatre Workers Act, the Dock Workers Act, and the Building and Other Construction Workers Act. So all these acts are captured under the Occupational Safety, Health and Working Conditions Code. Now, see, the whole idea of codifying all these existing legislations is to keep it simple, and to, of course, it's elaborative. All these codes are elaborative, and majority of the old provisions have been encapsulated even into the new labor codes. But at the same time, now, instead of checking or looking into so many other legislations, one has to just look into these four codes for understanding what are all the compliances to be done. Certainly there are some level of changes being done. So as RPs, we might be extremely acquainted on the amendments to the IBC, but at the same time, if we are appointed as RPs of a company undergoing in a company having operations, then we need to be sure even about our understanding of this updated labor law reforms. The reason is that any non-compliance of any of these labor law reforms, the first person to be made responsible in most likely cases would be the RP, because today all these labor law things, even the factories personnel and all, they are well aware of how this IBC is functioning, and they know that it is the RP who will have the highest authority in terms of decision making. So if there is any non-compliance, the show cause notice would 100% come on the RP, and we need to be extremely ready to respond to that. So for us, in order for us to be ready to respond, we need to be aware of what are these laws, how will they impact the operations, and how do I ensure compliance of the same, right? Now, since our topic is about navigating these labor law obligations by balancing the employee interest at the same time resolution, so let me explain it this way. Now, if I do a large number of non-compliances, the threat of that would fall on the new investor who is stepping in into the company. Let's say the investor steps in, does a site visit, the investor realizes that there are a lot of non-compliances. We are not providing the basic safety facilities to the workmen as required under the law, right? The machineries are not well maintained, or there is some level of threat to the employees which we see based on the working conditions in that particular unit, okay, or in the particular factory. Now, like typically where the company where I was the RP, every month in the first week we used to have a safety week where there was awareness programs to all the workmen in terms of the safety which they have to follow during the process, right? So I mean, during their working conditions and during the course of their employment or working in the company. So such kind of activities we were doing to spread awareness amongst all the workmen, emphasizing the need to prioritize safety over work, right? So even my steps, I mean, our steps as RP to ensure compliance of the labor law reforms can add more value in terms of the resolution, because the moment when somebody does this kind of a visit or looks into the documentation, maintain the kind of up to date compliances we do in terms of the labor law provisions and all, that would gain a lot of potential support in terms of negotiating with the PRAs, and also there can be a potential interest from the investors or the resolution applicants who would be interested to be investing in a company which is more compliant over a company which is at the verge of risk of non-compliance. See, one may argue that whatever non-compliances, costs, etc., will not be imposed on the new RA.
But at the same time, the one who comes in has to bring in all these conditions or all these compliances in place, right? So that would 100% be an additional cost on that particular PRA. So if we are able to achieve it, then they also have an assurance that till the time NCLT order is passed, the factory is in safe hands, and that can be run in accordance with the law without any risk of any potential non-compliance in the future, right? Anyway, as we move forward, in terms of workman versus employee, I think by the time um, yeah, and also by the time we receive the claims, I'm sure majority of us are already aware of this distinction between workmen and employees. But just a very simple criteria, that is just a classification of all the workforce. So generally, workmen are defined under the Act, like the Industrial Disputes Act earlier, and now under Section 2, Clause ZR of the Industrial Relations Code, wherein worker, so workman is now being defined as worker, right, which is a gender neutral term, like, as you know, workman versus worker. So now we term it as worker. It's a gender neutral term, where they define them to include manual, skilled, technical, operational, or clerical works. So all such works are considered as workers. And as regards the other employees, uh, any others who have managerial, administrative, or supervisory staff outside the definition of worker would come under the definition of employees, right? So that's just a point to note here. Right now, let's understand how the moratorium works and what kind of impact the moratorium has on the workforce. So when I say impact, I mean, like, as you can see on the screen, I differentiated it as to what things are stayed because of moratorium and what still continue, and because moratorium doesn't actually extend to such things, right? So let's first focus on the one which talks about what stays. All your litigations stay. Do any potential litigation or any litigation for the fact which has been filed in any labor court or industrial tribunals, etc., will be stayed, right? Any attempts of recovery or filing of execution petition for an award or decree passed prior to the liquidation process cannot be entertained, right? And no authority like EPF or ESIC cannot take any coercive action of recovery during this moratorium period, right? So these kind of litigations and actions of recovery during the process are stayed for sure. Section 14 operates. But in terms of your contractual obligations, relationship with the employees, right? Or your contractual obligations, your rights to raise fresh industrial disputes during the like employee, if they face any dispute during the process, then their right to raise such dispute during the process, right? And if suppose there is any hazardous activity undertaken and some like something happened during the process, which meaning like a casualty or injury to a worker which happened during the process, you cannot, as an RP, we cannot go and claim moratorium and escape the liability. That's not going to happen. So during the process, everything which a board should have ideally done, the company should have ideally done, you as an RP should also ideally do the same, right? Failing which, that's not going to help the company, so not going to help in saving yourself from the process.
Yeah. So that's about it in terms of moratorium. So in as regards moratorium is concerned, as I said, the employee relationships, like if there is an employee prior to the process, they will by default continue till you terminate them. So you cannot expect that the order of the CARP is a discharge of all the employees. Well, of course, it is applicable in the time of liquidation, but not at the time of CARP. Right. So let's proceed. Yeah, so this is just a very quick understanding of how the Sunil Kumar Jain versus Sundaresh Bhatt order of the Supreme Court, what has been laid down in that, and also in line with the ABG shipyard liquidation matter. So in this case, the two tests which we need to ask is, was the company managed as a CA as a going concern, and did the employees actually work or the workers actually work? So if the answer is yes to the both, then all these wages and salaries have to be paid in priority as a CARP cost, no doubt about it. And if it is no, then whatever funds are lying like PF or pension funds or gratuity, that alone will be kept outside the scope, and otherwise all other dues payable to them will come as per section 53, that waterfall mechanism will apply to them, right? So that's all about it in terms of the wages. Yeah. Yeah, in terms of the compliance playbook, that is, during the CIRP, what all compliances the RP has to ensure is: number one, of course, you need to do a thorough workforce audit, understanding who are all the workers on rolls, what are the PF codes of each organization, any pending inspections, what union agreements, if at all there are any union agreement between the company and the trade unions, the same, and the labor unions, the same has to be taken note of, and things like that, right? So communicating with the workmen, understanding their expectations, and all that would ideally be done during the first phase. Then, of course, considering the operations, deciding the going concern, whether we are continuing as a going concern or shutting down the show, is something which we need to decide. Then, payroll, right? That's one important regular payment which is going to happen and which is going to impact your CARP cost. So, therefore, a compliant payroll mechanism should be put in place to ensure that no workmen are misusing this. Then all the claims, of course, whatever claims come from the workmen, we'll have to thoroughly check from the company's records and verify. And uh, another important aspect is, there might be a chance that some workmen would not have filed their claims, but you need to understand that majorly all these workmen dues are part of the company's records. So when the company itself has all the records of all the workmen dues and labor dues, now it should not be what is stopping from the RP in disclosing the same to the RA. So we should ensure that in the IM all the disclosures are made, right? It may so, I mean the it may so happen that the RA may not consider if a no claim is filed, but at least RA will know that, okay, there are 100 employees, only 80 of them have filed the claims, while others have not filed the claim. So therefore, there may be at least some contingency fund which they may consider keeping, considering the total number of employee dues which are payable, right? So that's why correct the dues which are filed by the employees, at the same time, whatever are reflected in the books have to be thoroughly checked and uploaded in the IM, so that it is easier for the RA to look into and may do the plan of action. And of course, in terms of the plan due diligence, so while we are examining the plan, we should also make sure that as operational creditors, the workmen's rights are also adequately protected in accordance with the law. Now, in addition to all this, the regular compliances under the labor law should also be thoroughly conducted, right? So the RP has to ensure that all the compliances as required under the respective labor codes are duly complied with during the CIRP, right? And the challans, the PF and the ESIC challans are uploaded monthly on monthly basis with the respective departments. And if needed, the RP's name may be may be added as author signatory, and the 5A form may be filed, the DSC may be updated of that of the RP if needed. Otherwise, RP may designate either the company's existing director or the employees to continue doing that particular compliance. right? So these kind of technicalities also the RP might look into, because typically during the process also the PF gets accrued, right? So the PF dues and all has to be deposited. So that is possible only if you are making sure these compliances are done. Otherwise, there is no other way we can do the compliances. Yeah. Now, as regards claim verification, I'm sure we're all aware, the what is the form, the what proofs they can have to provide, and how do we do it. So I'm not spending more time on that. And I think even this we have already seen section 36 subsection 4. These are certain rulings which comment on it, or rather clarify in terms of why the fact that the provident fund or the pension fund or the gratuity fund is outside the liquidation estate and shall be payable in full. Now, this payable in full is an important aspect, right? So, after it was only after Jet Airways that this has become a great. This has become kind of one of the important to dos whenever we are reviewing a resolution plan. So now we need to ensure that all the gratuities, all PF or ESIC, whatever statutorily required funds for the employees are adequately maintained, right? And maintained, I mean that a resolution applicant proposing in a plan cannot give a haircut. They may still make a haircut of the salaries, but they cannot do a haircut of the PF dues. So PF dues is protected, and also any gratuity dues of someone that also ideally has to be protected going forward in accordance with the rulings which we have in the Jet Airways case. In fact, the Jet Airways case, the very reason why it ended up in liquidation is because of the labor intensive litigation, causing uh, the interpretation that the RA should deposit 100% of the PF dues and the gratuity. So that amount itself has become too high that the plan could not sail through, right? So that I mean, there are pros and cons, but at least today there is certainty. So RAs who are stepping in are aware that they'll have to make the full payments of these statutory liabilities, right? So that's about it here. And as we move on to our next slide on the waterfall mechanism. So the waterfall mechanism, we very clearly explained as to how uh, the waterfall mechanism functions, right? So first and foremost, section 36, as per section 36, subsection 4, the provident fund, gratuity fund, and the pension fund will be outside the liquidation estate. So they are not part of 53 at all. So you cannot use them for distribution under section 53 or for making payments of salary, a liquidator's fee or RP fee for anything for that fact. And as regards the waterfall, as you can see, 53(1)(a) is with respect to CRP costs and liquidations costs. 1B is for workmen dues only for 24 months, in pari passu with the secured creditor dues. 53(1)(c) is for the wages and unpaid dues of other employees for up to 12 months. 53(1)(d) to H are 1D is unsecured financial creditors, 1E is government dues and residual secured financial creditors, if any, who have not relinquished the security interest, and 1E is remaining debts, all other debts, unsecured financial debt, and everything will come. Sorry, unsecured is D. All other debts will come under E, which I also include operational creditors. F would be the preference shareholders, and H, the final one, is the equity shareholders. Only after anything is left, it will go to the equity shareholders. Now, if you ask me, just a very out of the thing question, if there will be any amount paid, has there been any case where employees shareholders received any surplus? I witnessed one case where even the shareholders have received monies, and because of some disputes between the shareholders, couple of shareholders title of shares was not being able to be proved, so therefore that money was deposited with the corporate liquidation account of the IBBI as well. So such things have also happened.
So, can you share the name of this particular case?
Sir, I'll tell you. It is Adhikari, Sri Adhikari Brothers, Sri Adhikari Brothers Television Network or something. So it was under liquidation. It was a pure family dispute. So they went under liquidation, and then finally
you know, the liquidator sold away all the assets. There was huge surplus even after making all the payments. It was much higher than the paid up capital, right? I think they received almost 3x or 4x of the paid up capital, which was also a good sum of money. It was pure family dispute. No, none of them wanted to take up the company or to resolve it, so they just left it open under the IBC, and whatever the assets were made, it was sold as a going concern, if I'm not wrong. So they received good sum of payment, and that was the only case I witnessed where I was there. Probably there are other cases where shareholders would have received something. I'm not aware, but this is one case I'm aware where shareholders have received some money. So, anyways, it's just a deviation,
No,
but I
no,
thought
thank
it's
you, sir.
interesting.
It's
Yeah,
just for personal information.
yeah.
Thank you.
Yes, yes, yes. Thank you, sir. Yeah. As we move forward, now this again an interesting aspect, as I think I've just kind of introduced initially during our discussion on labor laws, that what if the RP and the COC decides that let us lay off everybody? Like there is one factory, it's lying idle. We are, the workmen coming daily. We are making them payments for what? There is no production. There is no, visibility that we are going to use that premises for any production. And our estimated time for completion of this entire process, including RA stepping in, would all might take time. Now, RA might have proposed a plan whereby they say that the boss, I can only incur CARP cost. I can pay you whatever CARP cost there. It will be adjusted from the FC payment. No, such clauses are legally tenable also, right? So at such situations, the financial creditors recovery is directly proportional to how much they can save the CARP cost. So at that point, obviously, it will so happen that the the workmen or the payments made to the workmen are burdening the entire process and recovery. So now the tough call would for the RP would be that can I authorize such kind of a retrenchment during the process? And the answer is yes. Now, as again, since it's a simple yes, because if a director would have done it, if the company is not under CIRP, then RP can 100% do it if the company is under CIRP. The only thing RP has to ensure is similar compliances has to be taken care of.
Sir, I have a question over here.
Yeah, please, sir. Go ahead, sir.
I'm Pankaj Mehta. I'm from Delhi.
Yes, sir.
You just mentioned, in fact, I had actually raised my hand earlier also for the same thing.
Oh,
30,
I'm sorry. I thought you
no,
were
no,
on
that's
the
okay.
other thing.
That's okay. Because at that time it was tangential, but now it is not. Because
Okay, okay.
the 33(7), I think, is deemed discharge, right? That
For the
overrides,
liquidation. Yeah.
yeah, in terms of a liquidation, yeah, that overrides the workman's due and the
Yes.
notice.
Absolutely.
Notice that it has to be gained for 30, 60, or 90 days, whatever. Now, what you're
Absolutely.
mentioning over here is that in case, so but that itself is when we are selling, when it's a liquidation order, 33,
Only liquidation. Yes.
only, yeah. But now you're mentioning that during the CRP,
Hmm.
the RP has the option of actually putting the labor, the workers
Yes.
on what do you call it? Basically for a
Either
discharge,
layoff or
layoff or
retrench.
a
Yeah.
discharge.
Hmm.
Yeah. So, so won't that be a contravention of the Workers Act, Workers Compensation Act?
It would be. No, it would be. But at the same time,
Hmm.
the labor codes provide for a procedure how we can do that. So the only point I was trying to make is I can still do, but I need to ensure I am complying with all those provisions. And I cannot say, no, no, these are inconsistent with IBC, so therefore I need not comply. That will not work. So we still have to take, if so today they have increased the bar. Earlier, as I mean, I kept the threshold also as a last point. Like earlier, if the retrenchment or layoff or closure of a factory where the workers were more than 100, we had to take a prior permission from the the factories inspector and other commissioner of factories, etc. So
Correct.
that procedure was there. Now they increased that to 300 as part of the new revised labor codes. So wherever my workmen or my workers are more than 300, I'll have to ensure that I
I follow the procedures laid out in terms of prior permission to be sought from the respective authorities as per the Industrial Relations Code. And at the same time, I need to make sure that whatever retrenchment compensations have to be given, because once I retrench, I need to pay off whatever gratuities accrued till date, whatever. I also, for those
Severance.
who, yeah, severance package, that is the retrenchment compensation, which is equivalent to that of the gratuity compensation, that has to be made. And in fact, the new code has also introduced something called reskilling bonus or something. It is like a 15 days, half month salary. That also has to be paid. I mean, that will be technically deposited in a fund that would help the workmen to get reskilled, and they in the government will put in efforts to bring them some other new employment. So I'll also have to deposit there. So I cannot escape from these responsibilities. I cannot claim that these are CARP costs, let the RA come in, let them take it up. So I need to also balance it. I need to practically also see how I can make these payments, failing which obviously the workers are not going to leave, or there would be huge unnecessary issues of strike or other things happening on the company. So practically and legally, we need to make sure that we are balancing it, but at the same time, it is very much possible, but subject to we ensuring the adequate compliances of the law. So just because it is under CIRP doesn't mean that I escape these compliances, doesn't mean I need not make the payment of retrenchment compensation, etc. They are very much payable. All the labor laws will equally apply. There is at least as on today, there is no such provision or any ruling which relaxes or dilutes such requirements. So that is one aspect which I was trying to highlight. So that is the whole objective of this slide. So Pankaj, hope.
Yes, yes. I mean, I would rather, the last line I would rephrase from my perspective is
Yes, yes,
that despite the fact that CRP is going on and there's no liquidation order right now, the
correct.
RB or I don't know, the COC have the option of actually discharging the labor force, subject
Yes,
to requirements being met under the ID laws in Industrial Dispute Act.
understood. Correct, correct. Absolutely right.
Yeah, that's okay.
So
Thank you,
that
sir.
is
Thank you.
of this slide. Yeah, yeah. Thank you, Pankaj. Yes.
Yeah.
And of course, just to add on to what Pankaj has mentioned about the liquidation part, so that was the point 3 of the slide, that when at the time of liquidation, the order of liquidation, as per Section 33, it operates as a discharge of all the employees and workers. So at that moment, there is no such other conditions of the labor laws which would come into play, no retrenchment compensation nor nothing, because it's a discharge, it's not a retrenchment, it is not a layoff, it is not a closure of the plant, it is a complete discharge by operation of law. So whenever there is a discharge by operation of law by virtue of a liquidation order passed by the Honorable NCLT, none of the other provisions of the labor laws will come into force. The reason being simple, where there is anything inconsistent between both the legislations, the IBC shall 100% override. And more importantly, when there is something specifically provided in IBC, while the other legislations have something, whatever is specified in other legislation, but if IBC has anything specifically provided for a similar situation, then IBC will 100% prevail. So that's the whole reason why Section 238 had to be introduced. So once the liquidation order is passed, definitely none of these compliances will concern the liquidator. All workers who are there on board as workers will have to essentially leave, and they will not get any additional compensation because of the insolvency of the company. So that's about it in terms of this process. But this reminds me of one case in Telangana, which is, I think I should have kept aside. It's one of its own kind of resolutions which happened in the country. And in my knowledge, I don't think there was any other case which was resolved in the way this Sirpur Paper Mills Limited has been resolved in the state of Telangana. The reason why I'm mentioning the state is because this is one case or a case study where the government has involved itself by granting a bailout, right? By issuing a government order, a GO, giving various benefits for whomsoever who would acquire this company, right? As a resolution applicant under IBC. I repeat,
the government issued a government order specifying what all benefits the resolution applicant can enjoy if they acquire this company. And this was acquired by JK Paper Mills, and post that, like Siripur, like there is a political history also behind this case. I think one that is relevant for our point of discussion. So Siripur Paper Mills was shut for more than 3 years, and as part of the then government, uh, their campaigning, they campaigned saying that if we come into the power, we will resolve this situation of this workman. Right, so Sirpur paper mills were stuck for 3 years. The employees were not getting payments for 3 years. All the workers, because Sirpur is majorly known for the Kagaj, so they call it Sirpur Kagaj. Right, the Sirpur paper mills is what is the survival for a large number of workmen whose entire families, legacies are all part of that village. So they were on strike for almost 3 years. So the local MLA who contested in those elections is also part of that particular strike and is an active member of the strike. And he took a oath that he is going to resolve it if the party is coming to power. So the party has come to power. I mean, see, I'm not doing any political campaigning for any party. But what had happened was that subsequently they were looking out for a solution. Then the RP of this Sirpur paper mills, along with with his good officers, he was approached by them, and he also went. Probably, I'm not aware of those facts, but ultimately they were able to secure a government order giving certain benefits, like government assured that they will not charge any state GST for them, or that would be reversed to them for 5 years. Secondly, they allotted some piece of land for cultivation of this plantation, which they can use it for the paper production. Third, they assured that all the pending wages payable for that particular period of time would be taken care by the government. The one who is coming in only has to step in and take care of the prospective things and rebuild the factory, take care of the people and all that. So that will be taken care. And fourth, there was I just recollect these three on the top of my mind, but there were a list of such benefits. Around 7 to 8 such benefits have been provided, and subsequently that has encouraged the resolution applicant to step in and take over the company. Now just think, I mean, at least if any of you might be aware of such cases where the government has involved and has done a bailout, I'm not sure, but in my knowledge, at least this is one case where the government, along with the RP, the COC, the FCs, they all tried to resolve this company. Right now, having said this, in other cases, what do we see? After the RA takes over, they get notices from the factories department, they get notices from the GST, from the income tax. Everybody tries troubling the RA, who is the one who has absolutely no idea, I mean, absolutely no responsibility on such non-compliances or such defaults. He is not the one responsible at all. But still, they tend to send notices as a matter of thing, right? But I feel, I mean, of course, it's the same in Telangana also. It's not like it's any different. But this case of Sirpur paper mills, unfortunately, has not hit the headlines the way it has to. Probably that should have been one of a case study for governments also, to all governments rather, to identify such sick units which need some level of relief from the government so that it can be resolved. Because today we know, as RPs, we all know how many factories are being sold simply as scrap, just because they feel there is a huge unnecessary cost to be involved in reviving those factories. But the upside of it would be that if you revive, there's a lot of employment which can be generated. But what is happening? It is just being converted into another real estate. All the material will be sold as scrap, and the land will be sold to some real estate, and they're doing plots, and they're doing, I mean, like, the entire employment opportunity has just gone for a toss, right? So in my view, I mean, this is one important case where the workers strikes or the workers problems have gone to the notice of the government, and the government worked out a plan using IBC as a tool, right? Otherwise they would have had separate MOUs with the companies, or it would have been really difficult for them to bring a private party on board to take over the company if not for IBC. So that is the success of IBC in my view. That one case is a real success of
IBC in terms of how the workers' interests are being balanced. Like, in fact, that will clearly justify our title of navigating labor law obligations by balancing the employee interests as well as taking care of resolution of the company. So, if anybody gets a chance, I will try circulating this geo along with my presentation. I'd request all of you to kindly go through the set of benefits which the government had provided for, and probably in any of your cases, if there is a way for you, if you have good connections in, or someone who can connect you with the relevant department or the ministry, and if there is a similar situation, this case can be used as a precedent to motivate the respective governments to take up that as a challenge to revive the companies. So yeah, I think with this retrenchment and layout discussion, I was able to recollect this case study of Sirpur paper mills. Yeah, Pankaj.
Sir, just to you mentioned about Tirupur paper mills, Scooters India
Ah,
Limited in Lucknow. It's
uh-huh.
Lambretta and this thing. It's a
Yeah.
very iconic name, massive plant.
Okay.
So over there, of course, it was a government-owned entity, but in
Oh, okay.
yeah,
Uh,
but so what the government did in I think 4 or 5 years back, well, definitely after the IBC regime, that they
yeah.
extended a loan of over like 50 crores or something and hived off
Uh-huh.
a big land parcel back to the government. And then on the
Okay.
remaining, the monetization of the assets took place, and I think Ashok Leland took over. I'm not sure if I
Okay.
said. So they did, and the closure was handled by, of course, extending the loans and intra-department billing, and the labor was, of course, then somehow compensated or put across in
Probably
the
compensated.
new, yeah, because they were all end of the day they were all government employees, and this
Correct.
plant had been in either it was going in BIFR case. I'm talking about the BIFR regime way back in 90s. So
VAFR regime.
since yeah, so since late 90s it was like this. But the government
Oh
was
God.
proactive in this also,
Yeah.
just like you mentioning in
Correct.
Tirupur.
Correct.
Okay,
No, I
that was
think with government's activism, lot of things can happen. Lot of things can change. But unfortunately, it's very difficult for them also to focus on all companies. But yeah, but given a chance, I think there's a huge possibility of using IBC as a good tool by the government also. Yeah. Okay. So moving forward, in terms of the status of employees, like wherever we are doing a going concern process. So earlier we had three possibilities of going concern transition. One is by way of a resolution plan. Second is by way of Section 230 scheme under the Companies Act, which is provided under Rule 2B, Regulation 2B of the liquidation regulations. So a scheme of compromise or arrangement may also be proposed even during the liquidation. So that is second option. And the third was an option where, third was a possibility where we were selling the business of the corporator as a going concern, or the entire um, yeah, business of the corporator as a going concern, or the entire CD itself as a going concern. But as we are aware now, the liquidation regulations have omitted this going concern sale. So going forward, there is no possibility of yeah. So going forward, there is no possibility of doing a going concern sale under liquidation process. So the only two possibilities where we are looking for a going concern transition under IBC are: number one, a resolution plan, and I'm talking only about the corporate insolvency, obviously. Like pre-pack obviously can also be included here, but a resolution plan is the same, be it a pre-pack or a CIRP. And second would be a scheme under Section 230 in liquidation, which is a scheme of compromise. Now, in both these cases, under liquidation, under resolution plan, one has to ensure that whatever minimum payment to be made to the employees, including the PF dues, etc., are being taken care of. No, a scheme is an interesting aspect. Of course, the employee continuity, the question on who is going to continue and all will also be part of the scheme, just like any other scheme which you see under the Companies Act. But then what is more relevant here under the scheme is that it is a mix of IBC and the Companies Act, right? So honestly, the regulations till date do not provide an absolute clarity on how these schemes are being dealt with. The liquidators find it really difficult because each NCLT comes up with a different procedure in handling such schemes, and accordingly they follow whatever NCLT directs. But having said that, since it is a scheme proposed under IBC, there is some level of nature of IBC also involved, like that of the proponent of the scheme cannot be a 29A ineligible party, right? So that is one major important thing, and at the same time, some benefits like that of the minimum liquidation value or other aspects are also to be ensured, because that is how you're going to get the approval for that particular scheme. So that is all about this in terms of so that is all about it in terms of the employee treatment. So technically a plan, or like for instance, let us take a hypothetical case where a plan proposes that I'd like to replace all the employees. So as on the resolution plan approval, all employees shall be discharged from their from their work, and I should not have any responsibility to make any severance payments or anything to them. So it should not be considered as a cost. Let's say something like that clause has come. Now, the first and important thing as an RP I need to look into is as per section 30, subsection 2, clause E, where I look into whether the plan, or I examine whether the plan meets the statutory requirements, or whether the plan is in contravention of any of the laws applicable to the company, right? So that's also an important point for me to see. Now, just because it is a resolution plan doesn't mean the RA can ask anything as a relief from the NCLT. So that's not going to be possible. At the same time, can the RA ask for a discharge of all the employees? Possible, but subject to condition that whatever consequences apply in terms of the contractual obligation between the company and the employee as regards the termination, the same shall apply. Meaning 2 months notice period, yes, 2 months notice. If you don't want them to work for 2 months, then you make them the salary payment of 2 months. So typically, how, like if you are we like after the advent of AI, we have seen how majority of software companies started laying off their employees, right? The procedure is simple. There's a pink slip, you're going to be terminated. They'll give you 2 months. Either they pay you off for 2 months, or they offer you to continue your work for 2 months and then you'll have to leave, right? So that's the nature of the employment agreement between the parties. The same shall apply. Similarly, if you are discharging all the workmen at the factory, now it's going to amount to a retrenchment. Whatever benefits has to be paid to them will have to be paid. Will you pay it, or will it be paid as a CARP cost? Do you negotiate it with the FC? It's your headache. But the commercial implication of it cannot be diluted just because you are proposing it as a resolution plan. So employees' interests have to be taken care as part of your resolution plan. And I'm talking about companies which have running operations. So there has to be at least some observation on what you're going to do with the employees. Are you going to continue them? Then subsequently assess whom you want, whom you don't want, and then make a final decision. Absolutely fine. Or do you want none of the employees to continue? That's also fine. But you cannot mention clauses saying that you will not have any responsibility or liability towards it. That would amount to a contravention of the law. So technically, as a going concern, see that's where the ambit of discussion differs when you have a company with just employee dues but no going concern, versus a company with employee dues as well as going concern, and with a lot of employees already continuing with you under in the company. So in both these cases, in the first case, you have employee claims, but they are not working for your company now. So therefore, there won't be any implication for you. It's a smooth case. There's a payment of money to the creditors and the company is handed over. The RA will take it over from there. But if the company is ongoing, then you are not just giving the company's assets, company's fixed assets, or its whatever its operations alone. You are also transferring the employees, right? So instead of transferring them to a new company, the RA is going to substitute the shareholders and directors in this particular company, or the RA may even propose for a scheme of merger or demerger. Whatever it is, it will be operating in accordance with the law to protect the interests of the employees. Just because it is under IBC, you cannot bring in a clause in your plan to derail the interests or to derail the benefits eligible for an employee. So, even if we are on the side of the RA, and if we are drafting a plan and we know the company is having running operations and we have to continue doing the operations, in all these circumstances, we as RP should ensure that, we as the one who is advising the RA in this case have to ensure that the way we draft the clause should be in accordance with the law. So we also need to know the law which applies whenever we are terminating the employees, right? So that's one thing. We as RPs in this case at least has to ensure that when we are reviewing the plan, these kind of clauses are not being put to force, right? Now, yeah, some developments in terms of the labor codes which have been introduced. As we have seen, first one, the gender neutral term worker has replaced the earlier erstwhile term of workman. Certain thresholds have been increased, as again we discussed, from the limit of 100 employees, it went up to 300 employees now, where you are laying off or retrenching or closing a factory, where the workman is more than 300, only then you will apply for a prior permission. Otherwise there is no necessity for a prior permission. And yes, fixed term employment, like for example, if you are having a employee, right, for a fixed term basis, even if they are not meeting the 5-year bar, even with before they meet the 5-year bar, on a pro rata basis we have to continue to make the payment for them on a year to year basis to that particular employee, right? And in terms of wages, yes, this is a major change. I'm sure many of the employees have already witnessed this. The law now uniformizes this wage structure across organizations. Now you need to have a minimum of 50% floor on the basic, right? So you cannot have your basic pay less than 50%. Now this is one major practice. I think this is one of the important practices which we as RPs have to identify in a companies which are in going concern once we enter the show as RPs. It is that the generally to increase the you know the seat, I mean not the CTC, but the take home, to increase the take home salary of the workmen or the employees, this wage structure is usually altered, right? So that if you keep the basic minimum, the contributions on the calculations of the basic and DA for the purpose of PF contribution or other elements, that would become more or less lesser. So therefore your deductions on a month on month basis may become lesser. See, that was the reason why many organizations used to have a very minimum basic while they play with rest of the numbers and try to compensate you in terms of your CTC. But the employer contribution and both the employee contribution of PF and all will get we will have to be we will get lesser. So now what the government did was, as part of the social security measure, it's clarified now that your wage structure should be uniform meaning every employee should get minimum of 50% of their total wages as a basic, right? So that it can help in terms of your PF contribution or the computation of gratuity and things like that, right? So now all majority of organizations have actually revised their wage structures to meet this criteria. Next, in terms of negotiating with the union, so typically, if like see, again, unions is a different subject altogether, but just to keep it simple, your company may have more than one union. Okay, so there is a Trade Unions Act earlier now, which is, sorry, labor unions, which is now again merged into social security part. So the unions depend, and like all workmen may not be part of one union, they may be part of multiple union, right? So if more than 51 percentage of workmen are part of one union, then any negotiation on wages, working conditions, or anything can be solely done with that one trade union alone, right? Because the trade union has over 51 percentage of the membership of all the workers together. But in any case, if the membership of workmen in a particular union is less than 51% of the total workmen, in such cases, we need to identify, I mean, we need to negotiate with multiple unions at once so that we get the majority of the labor's decision making in terms of what we are negotiating. So that's what is one of the important changes. And yeah, now there is definitely certain risk in terms of transition, right? Now it means like let's, any past non-compliances, obviously there's nothing much you can do, but there are some interesting aspects practically. Like for example, a very simple example I'll give, and then we can move forward. Let's say the company, okay, let's say the PF dues were not paid for more than 3 years. No, that is not a problem because the RA will have to 100% pay. The real problem lies in complaints. Okay, PF dues are not paid for 3 years, but did you file the PF returns regularly for the 3 years? So that is a major question which RP should be concerned about. RP should not be concerned about the non-payment of PF. The point of concern of the RP should be more about the non-filing of the regular returns. The reason being that because the returns are not filed regularly, it will become difficult for the PF authority to crystallize its claim. Right? Let me put it straight. Let's say a company is admitted into CIRP, let's say today being 13th of August. Now, for the last 4 years, the company failed to file the returns and nor did it deposit any PF dues, but it deducted the PF from the employees. Now, it deducted but not deposited. What does it amount to? It amounts to a situation where the PF authority is only having data up to 2021, right? So, last 5 years, it is not deposited. Now, 2021, the company had 1,400 employees. 2022, the company had only 1,200 employees. 2023, 2024, 2025, by the time they came down to 2026, every year on year, 100 employees reduced. So today they only have 600 employees. Now, the PF records of the PF authority as on 2021 provides for 1,400 employees, and subsequently no return has been filed. Now, as per PF Section 7A and other assessments under the erstwhile PF Act, what do? They come up with assessments based on estimates. Now, what do they estimate? They estimate that, okay, the salary reported in the year 2021 for 1,400 employees, for each of the employees is this. Assuming for each of the employee, the salary increased by 10% year on year, plus none of the employees have left the company, or maybe 10% attrition. In fact, they'll not even put 10% attrition. They will continue with the existing employees only. They'll assume that all employees have continued so far, and they'll prepare a estimate and file a claim. Now, just think, as an RP, you are looking at this claim. Now, the claim might be an extremely higher amount, which is not matching with the amount reflected in the balance sheet. Obviously, that's one part of the story. Now, let us think, okay, because PF authority has submitted, it's an estimate signed by the relevant authority. We don't want to dispute it. We don't want to get into litigation. Let us say as RP, we have admitted the claim in full. Okay. You may think, boss, what is there in admitting a claim? Your role is not to adjudicate. You're just verifying, collating and admitting a claim. Just do it. Okay, fine, I did it. Now, once the plan gets approved, because of the Jet Airways ruling, we are all aware now, that 100% payment of PF is mandatory. So therefore, the RA will propose for 100% payment of PF. Now you are making, or rather overpaying the PF to the PF authorities. Now PF authorities, they will have to ideally credit the PF amount to the respective employees. It is not a recovery by the PF authority. They are only taking it on behalf of the employees. They have the responsibility to credit it back to the respective employees. But how will they credit when they don't have the returns filed on the PF portal? Now, this is actually the problem. And this is the problem PF authority is facing in multiple organizations, because they don't have the exact data as to whose accounts of PF this amount has to be credited for. That is causing a huge confusion in the PF office, right? So, as RPs, if we are part of a company undergoing CIRP, or if you are undergoing CIRP and having operations, therefore you're going as a going concern, or assume it's not a going concern, but the company is still being sold as a going concern with some PF dues being payable. In these cases, firstly we need to understand who are eligible for this PF dues in the past period. What is the data? Try engaging a labor law consultant or someone to make sure that these records are straightened and are submitted to the PF office or through the online portal. E-filing has been done so that there is a crystallized amount of dues payable, and the PF authority will also be satisfied with respect to the same. Only then any amount received by PF will actually hit the accounts of the employees. Otherwise, it will just keep be lying with the PF authority, right? So yeah, that's about it. I thought the transition risk. This is one thing which RP has to comply during the process. Yeah. So any questions from anybody so far, or can I just? I mean, we are anyways about to continue. I mean, about to finish. Yeah. All right. Now, as we move forward, in terms of just to kind of get things together, first and foremost, the idea of the labor laws, as well as the notion or the context in which we need to function, is to protect the interest of the workforce, right? So the RA in its plan has to ensure 100% payment of such statutory dues, which are PF, gratuity, ESIC, etc. And during the CIRP, whatever wages are accrued has to be paid in full. And if a worker fails to file a return or fails to file a claim, right, that should not stop you from disclosing the payable to the worker based on the internal records of the company. And finally, any communication with the workman or the employees, better and safer is to always do it through the representative and not like a open town hall, right? Because town halls are good and positive when the company's situation is good, but if you are dealing with a situation like this, first and foremost you should initiate. It's better, always better to initiate the talks through a representative, and of course subsequently, if needed to give better assurances or to boost up the morale, definitely we can take up the next round of talks with the workmen at large. But it's always important to keep the authorized representative or the labor union leaders or those representative employees in a good book, so that they ensure that the communication is being conveyed in a positive manner to the employees, right? Now, in terms of the employee interest, one concern is, because the PF authority has to be paid in full, that is directly impacting the recoveries to the secured creditors. Now, how is it? Is because, see, any resolution applicant would come up with one value to the entire company, right? So they are not going to propose any additional payout, right? So they know that this is the value I can invest in this company, and then they will further discuss as to how to divide it amongst the respective uh, uh, stakeholders, right? So now, because of this particular condition that the PF has to be paid in full, all these amounts are being routed to the PF authority, thereby reducing the recovery to the resolution, I mean, to the financial creditors. So that is definitely one of the issues. But there's nothing. I think now, even the bankers have come to terms with that, with such clauses. So I don't see that as a bottleneck anymore. But 100% that is having some impact on the recovery. So probably it makes sense for the bankers now to even keep tracking what amount of PF dues are there, because tomorrow that can be a bottleneck in their recovery, right? So that's one part. Yeah, so that's about it. And as we move forward on the rulings, I think the Sunil Kumar Jain's case was the first of its kind initially in terms of the Section 36, subsection 4 interpretation. And the Moser Bear Karamchari Union, the union itself has filed its claim. Sorry, filed this particular case. Then Jet Airways, again, it's the staff who has filed the claim. Then again, Moser Bear Karamchari, the same, the NCLAT ruling initially. The precision fasteners case, then P. Mohan Raj Shah Brothers is part another important Supreme Court ruling, and Arun Kumar Jagatram ka versus Jindal Steel in terms of 29A. So this may not be directly, um, uh, you know, uh, apply. It was more about the eligibility under 29A for a party to come in, but then in this case, um, the reason why I introduced this case is because the promoters in this case argue that their scheme is going to save the employment of the workmen and all, right? So that is how the argument is rooted. So that's one part about it. So yeah, that's about it. Now, just one last slide before we conclude the session is what as RP we need to do in terms of this particular compliances is number one, make sure we are depositing the EPF and ESA on time, and we are it's a non-negotiable CRP cost. Nobody should come and argue on it, right? But I know there might be a challenge of cash crunch, then at least do it delayed, but just do it, right? Then make sure you are documenting the going concern decision that your company is going concern in the minutes very clearly, and explaining the necessity of the workforce. Then keep quantifying the dues of PF and gratuity separately, so that the same can be clearly specified in the IM and cross-checked from the resolution plan, and also monitored during the implementation phase for distribution. Of course, at the time of claim submission, clear distinction between workers and employees is necessary, because the Section 53 operates differently for workers and employees. And all the compliances and the analysis on the labor laws compliances has to be clearly done, particularly from the point of view of the post transition phase upon enforcement of the four labor codes. Right, so that has to be taken care of. Now, as regards the don'ts, non-filing of a claim, ideally, we as RPs should not look at it as an absence of the claim. It is our responsibility to disclose in the IM as to what is payable as per our books. Now, whether they file a claim or not, whether the plan provides for it or not, is a different story altogether. But it's our responsibility to mention it as part of the IM. Now, we can't, of course, let down any PF for gratuity to be crammed down, because the Jet Airways ruling is there, right? Now, we can't assume a Section 238 kind of a provision, which is the non-obstante clause, to suspend the labor welfare statutes, right? So because it does not, right? The labor laws and the labor welfare legislations are intact, and they are equally applicable during CIRP. Just because we are under IBC, there is no relief granted, because these are all beneficial legislation, social legislation, which are to protect a group of people. So a company under IBC cannot take away that protection, right? So their safety norms, payment terms, these are all the basic bare minimum things which has to be provided, irrespective of whether the company is under insolvency or not. Now retrenching, yes, again, if suppose, let's say, you decided you want to retrench all the employees, that doesn't mean you simply send emails or simply send letters telling them, okay, you're out, right? You should also see what are the repercussions, what are the commercial implications or the financial implications of the decision, and also what compliances has to be done in order for you to do the decision. If there is any prior permission required based on the strength of the employees, that has to be done. And definitely you cannot reject or ignore the pending industrial disputes, where such disputes are pending as on the insolvency commencement date, and such employees or workmen file their claims based on the case papers. At least some estimated value we will have to consider based on the value. But otherwise, if it, because it is sub judice, then we have no other option but to give a nominal value. But then the same has to be clearly disclosed by way of an IM in the IM to the resolution applicant, so that they are pretty well aware that this is what is happening. So this is all about our discussion on
Sir,
navigating the.
I had a question here, Prakulji.
Yes, Ganesh sir,
Uh,
please.
Sir, basically, I wanted to know, like, recently there have been some precedents on the uncrystallized claims, right? Rachna
Yes,
Jhunjhunwala has also been upheld, as you may be aware, like after the NCLAT judgment.
correct,
This is basically
correct,
that dues, pre-CRP dues have to be, crystallized and should have been finalized before the commencement of the ICD. So what do we
correct.
do, like, practically in such situations? Because we still see the PF department delays, and there are certain procedure to be followed with them and all that. So now, what should we do practically as an RP? In lieu of these, in the light of these judgments by the Supreme Court also, because Rachna Jhunjhunwala also has been upheld now by Supreme Court. Just wanted to know your
Correct, sir.
thoughts. Yeah, yeah, yeah.
No. It's a good point to be discussed, sir. In fact, Rachna Jhunjhunwala is a recent precedent, as recent as end of July, if I'm not wrong, 28 or 29 of July, the Supreme Court has passed the ruling. So I was just, let me just open the ruling. One second.
Mm-hmm. Yeah.
Yeah, sir, I'm just sharing that on screen for the interest of everybody, because I think that is a very important discussion, because just to set the um, uh, you know context right. So typically what's happening is PF authorities, I don't know if any of you have observed recently, in one of my cases, what happened was I received a claim from the PF authority, and the language goes like this. Maybe others also would have observed, probably Ganesh sir, you can also comment on this, that they give a covering letter saying that as per the Supreme Court order in Jet Airways, dash, 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 we need not submit our claim because our claim has to be paid in full. Nevertheless, I am still submitting my claim only under IBC without prejudice to my rights. Please make the full payment of the PF dues immediately. This is how they are addressing letters.
This is there in every communication standard, copy
Yes.
paste there. It is
Yes,
there.
sir.
Yes.
Sir, it is a blatant violation, sir. Like,
Yes.
the law doesn't say that you need not file a claim. The law
Yes.
says PF dues are protected. No, it is your responsibility to file a claim. But
Absolutely.
unfortunately, they write and they treat RPs as if, who, I mean, I am not bound by you. I have to be paid my dues in full. And they also extended their argument to say that even their damages and interest have to be paid in full, which
Yes.
they are contesting in multiple legislations, which is again going against the Supreme Court ruling. Supreme Court definitely protects the PF dues, because those PF dues will go to the account of the employees. Whereas
Yes.
the interest and the damages will go to the account of the EPF authority, whereby you
Correct.
are like any other statutory authority, you are like any other operational creditor, you will be treated accordingly on par with other statutory authorities, but which they are unable to take. Whereas this ruling, at least two paragraphs which I feel have kind of addressed it is, for instance, this para 12, sir. Here it says the resolution plan provides for payment of PF dues, even though it does not provide for uncrystallized claims of interest and damages, regarding which proceedings were not initiated by the CIRP commencement date. Therefore, in our view, there is no blatant violation at all. So they are basically, even though, of course, the facts of the case might vary, how it is being interpreted, but ultimately, the PF dues are something different from that of the interest and damages. At least that distinction is
Correct.
clear as part of this ruling. And
Yeah.
secondly, where you were unable to crystallize it prior to the CIRP and the plan does not provide for it because you have not crystallized it, the Supreme Court is not finding a fault with it. So therefore,
Correct.
Supreme Court says, boss, it's still fine. So I think, sir, interpreting this, when there is an impossibility of crystallizing something, then I don't see a plan will be finded fault with, because it could not be crystallized at the time of insolvency commencement. At the same
Correct. Correct.
time, sir, maybe we can take an example. Like, let's say there is an operational creditor who there is a pending dispute. Like, company is disputing that your material is wrong, so I am not going to make you a payment. While the operational creditor says, boss, you have consumed my material and you also made sales, whatever. Some litigation is ongoing and the case is pending. So therefore, what can we do as RP? I can't adjudicate it. I can't dispute it, because I can only litigate cases which can benefit me. Here, I won't litigate. I will just admit your claim at a notional value. Now, what can happen, sir, in my view, is that as part of the plan, we should at least ensure that RA provides that, okay, even if suppose, let us assume they have a claim, then what would be their payout? Their payout should not exceed what I am proposing to all the operational creditors. So technically
Yes.
speaking, I will provide this bunch of amount to the operational creditors. Now, you tomorrow, after this entire thing is gone, ideally all cases and liabilities against me are deemed to have been extinguished as part of this. But still, if you want to litigate it and get a relief, if at all, let's say there are some cases where Tata Steel, there was some case against Tata Steel, there was one litigation like that where the Bombay High Court, if I'm not wrong, or sorry, the Madras High Court has given a comment saying that the other party can very well continue the litigation. Only point is they cannot claim the full amount from the RA. They can only crystallize their right. But if they crystallize their right, and then ultimately they're going to get the same proportion of any other operational creditor. But why, sir, these cases do not come much into the foreplay is because the operational creditors hardly get any recovery anytime. So
Correct.
therefore, nobody continues doing it also. Otherwise, if you see Section 60, sir, Section 60 has under the IBC has a clause saying that you will get protection of limitation for any cases filed by or against the CD. Now, that is again a very I mean, I shouldn't say contradictory, but it has. Let me just take that also on screen because it has some relevance to our discussion. Just a second.
Yeah. No, in my view, sir, the main point, moot point here is nobody is disputing the Section 36, priority that PF has and the
Correct.
super
Correct.
priority that they claim. The
Yeah.
whole point boils down to the mere fact that IBC is a time-bound process. They need
Correct.
to provide the claims on time for this, for
Correct.
further validation by the RP, and only then
Yes.
they can then claim a right. You cannot sleep over your rights, right? That is what the law says.
Agreed,
Because
sir. Very
in
true.
one of my
Yeah.
cases also, NCLT has, I have one in the NCLT where they have relied upon the Rachna Junjunwala judgment. Of course,
Oh,
in my case,
fantastic.
the company was in liquidation. Okay.
Okay.
There also they had, delayed in filing the interest and damages. I had paid the principal dues, but interest and damages,
Okay.
they have done the belated calculation. And usually the
Uh,
argument which they take is that the principal dues have to be paid first. Only then they can
uh,
calculate interest and damages. My point is that if that logic is used by TDS department or say GST department, will it hold good?
It
There
makes
is
sense.
always a
Yeah.
provision to do a tentative calculation. You can do a tentative
Correct.
calculation, or you can do a estimated calculation. System is allowing you to do that, right?
Yes.
So then once you place it before the RP, then he is bound to consider it as a crystallized claim. So that is
Correct.
the yeah.
Understood, sir.
Uh,
So,
uh,
sir, in your case, so what happened, sir? Ultimately,
Yeah, yeah.
like they gave the distinction between the damages interest and the principal. That
No,
damages
no.
interest cannot
My
be.
case, yeah, I'll just
Yeah.
briefly tell you. In my case, the interest
Yeah.
and damages were all
Ah,
actually pertaining to the pre-CIRP period. For that matter, even the principal dues were for the
okay.
pre-CIRP period. Now,
Okay.
as per my books, I had the principal dues which were more or less matching with what is the actual dues, maybe some 4 or 5 lakhs here and there. So, as you have
Okay.
showed in your first slide, we are also bound by the books of account as the RP, right? So, I
Correct. Correct.
considered that in my IM, and I have segregated that in my section 36 also from the liquidation
Okay.
estate. And the
Okay.
7A proceedings were concluded. This happened around 7, 8 years back. I was also new to
Okay.
PF. But the thing is,
Correct.
interest and damages they calculated after 7 months. By then, I have
Okay.
distributed money to all the other financial creditors. Right. And
Yeah.
I've informed them also. I've informed them saying I'm going to segregate the principal dues. I'm proceeding with the other distributions. They don't
Yeah.
see the communication from the RP. That is another, challenge.
That's true. That's true. They don't
Yeah, yeah, yeah.
acknowledge. Yeah.
They don't
Uh,
acknowledge, they don't read the entire communications. That is the problem. So
mm-hmm.
then they have come too late in the day, and then I've rejected the claim. Then they've gone before NCLT. NCLT,
Mm.
after, first they wanted to condone the delay. NCLT condoned the delay. Then after that, NCLT asked me to verify the claim as per IBC law. When I verified the claim as per IBC law, the concept of moratorium, all those things which you are aware of, right? Various case laws are there. We have put
Correct.
forth. And then based on that, NCLT has relied upon the Rachna Jhunjhunwala judgment and some other judgments to say that when
Mm.
something is not calculated as on the ICD, right, it cannot
Mm-hmm.
be considered as crystallized. It's an uncrystallized claim. So therefore, it
Mm-hmm.
cannot be excluded from Section 36. The protection cannot be afforded to something which is not crystallized. So that is the as on date where it stands.
Understood, sir.
So anyway, they have gone
But
on appeal before NCLAT, but we have to
oh,
fight it out. Yeah, yeah.
so just one doubt here. If at all, let us assume that it was already crystallized, but can we
Yeah.
still make full payment of that interest and damages? Is it liable? Are we liable to pay, or will they come under any other operation? Because I was thinking, in my view, PF dues 100% you need to pay because that is liable to be paid to the employee, whereas your damages and interest is technically as an operational debt by statutory authority, which should not get the priority. Is my opinion.
No, I agree. But going by these judgments which have come, Jet Airways,
Ah,
then this one more judgment is Sunil Kumar Jain. All
correct.
these judgments are because of that, the whole thing is swung in their favor. That
Mm,
interest and damages also to be
yeah, yeah,
excluded. Otherwise, my personal view is damages goes to them. Interest
correct,
also goes to that,
correct.
fund, provident fund itself. It doesn't go to
Fund
the
only.
no,
Only the
pays
principal
separately.
goes to the employees.
Only the principal goes. Yes, yes.
Yeah.
So, Prakulji and Ganeshji, I have just one question about what you
Yes.
mentioned. In case of the interest and damage non uncrystallized, that's okay. But in case the returns have not been filed, in case of the non-compliance that you were talking about,
Yeah.
yes. So
Correct.
how does that that particular situation and paragraph 12 of this judgment,
Correct. Correct. So, in fact,
the
sir,
CD has not filed in his returns. So,
yeah, yeah.
so
That's the
how
very
will they
reason we
crystallize
say
it as on ICD?
correct, 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 correct. So, the whole idea is that when you know the CD has not filed for 5 years, what were you doing all this while you just become active only because the CARP order has come? So that is the whole context in which this discussion comes up. So the PF authorities are never proactive when they see that the company is not filing the returns, not depositing. In fact, sir, the BNS, the Nyaya Sanhita, which we have today, the Bharati Nyaya Sanhita, and earlier IPC also, one of the sections provides for non-deposit of employer's contribution with the PF authority is a criminal offense. In fact, anyone can file a complaint before the
police, and it can be registered against the company's officials. So that is a criminal offense, but unfortunately neither employees do nor PF authority initiates it. And in fact, leaving that aside, PF authority can take an action as early as even 1 or 2 months of delay in filing of returns, but neither do they send any show cause notice, neither do they start any assessments. Only after some complaints go to them or some level of pressure is on them, only then they do all such tactics. So whereas now under IBC they know that, okay, once IBC
Another interesting observation I have.
yeah, go ahead sir, go ahead.
No, like you very rightly mentioned, even in voluntary liquidation cases, when we are shutting down for 5 or 6 years, they do the assessments in one go. Okay.
Yeah.
I sometimes feel like asking, when it is a live company, why don't you issue notices? And you won't believe, in some of the voluntary liquidation cases, for consultants who are hired and for professional service providers also, especially more for consultants, they want to reclassify them as employees, assess the 7-8 dues, and calculate interest and damages. Interest for 4 years would be huge, sir. And damages,
Yeah,
of
very
course,
huge.
now because of that Vishwas scheme and all, it is reduced a little bit. But they do it in one go after 4 or 5 years. The very, the voluntary liquidation itself turns into an insolvency project.
That's correct. They make the company insolvent because of that. The solvency is the question. Yeah. That was the 6-7 years is too much of a time for a department to come back, sir. So I think this para 12 now will threaten them for sure. They will now try to be really proactive whenever they see anything more than 1 year or 6 months. They should now start initiating their assessments.
True. Yes.
Yeah. Okay. So I was just showing one section, so the interesting one, which I felt probably based on your discussion, I thought we'll just quickly share this. So if you see this part, sir, it says under section 60, subsection 6 of IBC, it says, in computing the period of limitation specified for any suit or application by or against a CD, right, the period of the moratorium in place shall be excluded. Now, this indirectly is indicating that if there is a pending litigation prior to the CIRP, and not, I'm just generalizing the question, not just PF. Let's say there is some uncrystallized claims of operational creditors or another financial creditor. There's some dispute ongoing, some arbitration is ongoing, right? So there is still a possibility that litigation can continue. If I look at section 60, subsection 6 standalone, it says that whatever period has been gone under moratorium, that will be excluded from the period of limitation. So if you have not initiated something before, you can still have a chance to initiate it against the company, do the arbitration, get an order. Only question would be your recovery. You cannot go against the new RA because there is a clean slate. You can still initiate or continue a litigation using this section, quoting this section, saying that I am still under the limitation, and get your rights crystallized, then fall back to the resolution plan to see how the contingent liability is being addressed. Now, this, if I read with the order, let me just share the order. In the order, one interesting point, which is out of context, what it says is, if the liability of CD towards interest and damages are not determined and finalized before the commencement, they would fall in the category of a contingent liability. Now, to assuage the concern of stakeholders, the COC in its commercial wisdom may provide for a lump sum amount to meet contingent liabilities arising from uncrystallized claims. However, if the COC has not provided for such contingent liabilities in the plan, its decision cannot be faulted because the underlying object of the CIRP is to adhere to fixed timelines. If the PRA is kept guessing as to what he would have to pay to take over and run the business, it may not enter the fray, therefore, thereby defeating the underlying object. So, besides, approval by the COC cannot be declined, can be declined only on standard grounds of 30 subsection 2. So, basically, they're trying to say, if the plan does not provide for contingent liabilities, you cannot fault because you can't expect the PRA to keep on guessing what he would have to pay. Now, this is kind of contradictory to what we have just read under section 60, subsection 6. So, but at the same time, it also says that there can be a possibility that COC may provide for a lump sum of amount to meet the contingent liabilities. So, I feel whenever there is a contingency, ideally the plan should provide for it. The plan should address it. How you are dealing the contingent liabilities. Like, are you making any payment? Do you don't want to make the payment? What exactly is it? because this is again a very gray area, sir. Today there is not much of it, because typically all litigations are by operational creditors, and always, or majority of the cases, their recovery is zero. So it makes no sense for them to go litigate at a later stage, because even if they win the litigation, they can at the most claim what any other operational creditor has claimed. So they will still get the same zero. But this section 60 subsection 6, that way, in my view, is a very interesting provision, because it still keeps that open, because it uses the word by or against the corporate debtor. So yeah, Ganesh, sorry, you were saying something.
No, it's very well put forth by the Honorable Supreme Court. The
Yeah.
paragraph which you read, it's nicely put in terms of
Yes.
contingent liability. It can be, or it cannot be faulted with if it is not provided
Yeah.
for. So
Correct. Yes, sir. Thank you, sir. I think it's interesting to discuss such practical issues. So yeah.
Sir, I just had one more question on
Yeah.
gratuity. While
Yeah.
PF, so if for gratuity liabilities, as we know, there is a trust structure also where the funding
Yeah.
happens,
Yeah.
usually in the company. In some other cases, they don't fund and it's pay as you go method, right? So
Correct.
in that context, if it is if there is any gratuity liability which has to be paid during this CRP process, I'm not aware. I wanted to know your experience. Does it include only funded, or does it include unfunded the liability as per the books? Like, how do we go about it?
Yes, sir. So the two ways of looking at it, sir, as what you said.
Hmm.
Firstly, let's say it's a shut operations, nothing is there in the company, but there was some fund lying. Then it's straightforward, as you know. I will exclude that fund, and I will make sure whosoever are the beneficiaries of the fund, as per the gratuity and as per their tenure with the company, we will ensure that that fund will be distributed only to those eligible employees. So that we will anyways take care. Now, assuming the company never maintained any fund, it is all payable. Then, and if I am going under liquidation, then technically there is nothing which is today telling me that you have to pay that gratuity on priority. For PF, there is a clarity. And even for gratuity, the Jet Airways order still says that gratuity also has to be paid in full, but that is only during a resolution process situation. But if it is a liquidation situation and I don't have any funds, though I will still treat it as a workman due under that 53 1B, 1C, 1C for workmen and employees, but I will not treat it outside the 53 if it is unfunded. If it is funded, I think it's straightforward. I will treat it outside. But if it's unfunded, unlike PF, this gratuity per se will not get that full priority, sir. I mean, at least
Understood.
as per the instance. Yeah.
Yeah. So
Uh,
basically, what you're saying is, if it is funded, it gets excluded under 36.
yes,
Otherwise,
100%.
we have to go under 53 workmen's dues itself. Okay.
Correct. Correct.
Okay.
Yes. But again, having said, these are all very contentious things, sir. I always feel whenever Supreme Court gets a
True.
chance
Yeah.
to
Yeah.
look into these kind of things, Supreme Court should actually go all in and give a detailed order. Even if you see the the Junjunwala order, it is a 8-9 pages small order. I think Supreme Court should dwell into in depth explaining the nature of PF dues, why is it protected, how should it be protected. I mean, some jurisprudence has to evolve. Otherwise, people like you and me will suffer when in
No,
our
everybody. We
yeah.
are having so many live cases before NCLT,
Yeah,
NCLAT.
they are also litigating. PF is litigating left, right, center.
Yeah,
So it's
left,
a
right, and
very
center.
hot topic. And whenever Supreme Court gets an opportunity, I don't know why they don't go in detail. I mean, at least they should take it as an opportunity, just like how Swiss Ribbons, even though the
Yeah.
dispute was something, they went ahead and gave a lot of commentary on IBC. Because that was the need for them to justify the constitutional validity of IBC. Similarly, whenever something comes up on EPF or something on this kind of employee-related thing, I feel Supreme Courts might go a bit more detailed so that things will become more interesting.
It's a very pertinent observation, Prakulji,
Yeah,
because that is what will give more clarity on day-to-day issues. It has to be
correct,
in-depth analysis from beginning to end.
correct, sir. Yes, thank you. Actually, the last half an hour was very interesting for me also personally. Thank you. So, any further questions from anybody else, or any further discussion somebody would like to talk about, or anything differently happened in any of your cases which you'd like to bring to our notice, any orders which you feel are interesting, please welcome. Otherwise, I'm done with from my end. I'm more than happy to discuss anything or answer any questions. Otherwise, we can conclude the session. Okay. So thanks everybody. Thank you, especially Ganesh ji and Pankaj ji for for discussing. This interaction makes it really lively and active. So thank you so
Not
much
at all,
for
sir.
adding
Thank
the
you so
point.
Thank you
much.
very much, sir.
Thank you, sir. That's about it, sir. Thanks everybody. This is from. I
Thanks.
mean, I'm
Thank
done
you.
from my side. I request the ICSI to maybe take it forward and close the session. Thanks. Anjali ma'am, you can conclude the session.
Yeah, so I extend my sincere thanks to you, sir, for giving your valuable time and share your experience on the topic, navigating labor law obligations under IBC. Thank you very much, sir, for sharing your learning. The session was very wonderful. Sir, you are
Yes.
requested to kindly share the presentation of your session, please.
Yeah, I will 100% do it, ma'am, right away.
Yes, sir.
Yeah. Thank you, ma'am. Thanks, everyone. Bye bye.
Thank you, sir.
Thank you. Bye.